Alex Burnick for appellate.
Good morning, Mr. Steele. Good morning, Mr. Burnick. Once you get yourself settled, Mr. Steele, you may proceed when you're ready.
Good morning. May it please this honorable court, my name is Brian Steele, and I represent appellant. On May 24th of 2019, appellant was indicted for participation in criminal street gang activity, malice murder, 3 counts of felony murder, 3 counts of aggravated assault, criminal damage to property, possession of a firearm during the commission of a crime by the Fulton County Grand Jury. Appellant went to trial with other counsel, and the count 1, which is the gang count, was severed or bifurcated, so that did not go to this jury. On September 30th of 2021, appellant was convicted of all of the counts of the indictment that went to trial. He is currently serving life in prison plus 25 years, and that's all at record page 7 through 14 and 354 through 356. Appellant has raised 4 enumerations of error. The last one is cumulative error under State versus Lane. Unless this honorable court directs me otherwise, I'd like to discuss the first enumeration of error, which deals with a witness being sworn and on most of the questions invoking her Fifth Amendment right not to answer the question. The facts are very simple. They're tragic. There's loss of life here and destruction of lives throughout. It is 3 gentlemen are in a car. Not that it matters, the car was stolen that day in Cobb County. They drive to Fulton County. They come here because they're speaking with a woman named Miss Hartfield. Miss Hartfield explains to the gentleman that if they come to Atlanta area in Fulton County, they will be able to get high with girls and have sex. The 3 men come, they pull up, it is early morning hours, and Miss Hartfield and another young lady named Miss Smith are in the car with the gentleman. Miss Smith exits the car purportedly to get the marijuana. Miss Hartfield actually did that. Miss Hartfield comes back a moment later, asks Miss Smith to come with her. As soon as Miss Hartfield and Miss Smith were away from the car, gunfire erupted. The car was riddled with bullets. The front passenger was fatally wounded. The driver tried to leave. The car was disabled. The driver and the rear passenger flee. And Ms. Hartfield is on the phone later, and it's videoed. It was a FaceTime call, and it's videoed by a different person, a witness named Mr. Bell, and is being asked by one of the surviving witnesses, did you set us up? The law enforcement gets the information, and they find and take in that night Miss Smith. She tells law enforcement, I don't know what you're talking about. I have no idea what this is about. Eventually, after 2 hours, she is confronted by law enforcement. They're very sophisticated, very accomplished homicide detective with City of Atlanta, and she then implicates appellant, the co-indictee, and Ms. Smith. Ms. Smith tells law enforcement, I don't know what you're talking about. Pursuant to Instagram messages that the trial court allowed into evidence, it was identified as appellant and the co-indictee speak with Ms. Hartfield, and Ms. Hartfield explained that Ms. Smith snitched, told appellant's name, gave Ms. Hartfield's name, and appellant responded, I knew that she's a rat, and what did she say about me? Those are not the exact quotes, but that's the way it came out.
So that sets up the facts for what is an IAC claim around her invoking her Fifth, is that right?
Yes.
Can you articulate for the court the nature of the IAC claim? And for me, I'm interested in the prejudice side of it as well.
Okay. So Ms. Hartfield is going to be a witness. She's in custody at the time of trial. she announces she is her own independent lawyer. Her lawyer announces to the trial court that her client will not be testifying, and she does that properly. Everybody agrees it's proper because Ms. Smith is potentially set up this murder. She was close to the murder. She's on the phone afterwards with the supposed killers, the co-indictee and appellant. She lies to law enforcement allegedly about she wasn't there.
Was there any indication that Ms. Hartfield was going to testify about anything?
She did testify to things that were not germane to appellant's trial. But yeah, she answered that she
What
knew.
about the threats? Those weren't germane? The fact that she said she was threatened to not talk, or maybe someone said they were going to kill her?
Yeah, so that came out that the victims, the living victims, that their friends, family, supporters, gang members, whomever, were threatening Ms. Hartfield because she supposedly set up the death of the deceased in the
So,
case.
counsel, let's contextualize what we're doing. There's no question, at least in my mind, that the procedure in the trial court, the best practices for a witness invoking the Fifth Amendment were not followed. I mean, the precedent sort of lays out, this is the best way to handle a witness who is going to invoke their Fifth Amendment rights. We don't really like that happening in front of the jury. That's not sort of the best practice of how to handle it. But it doesn't require that, right? I mean, in other words, the precedent that says this is sort of the best way to do it doesn't say it's the only way to do it.
This was pretty much the worst way to do it, but yes, I agree with you.
So because you're coming in through ineffective assistance of counsel, you have to demonstrate that no reasonable lawyer would have considered this to be beneficial to their case. And while I understand, I was going to say it because you're bound by your prejudice arguments. Independent of that, your argument is, hey, look, there's not overwhelming evidence of guilt here. Assuming I don't accept that the other evidence that was coming in was pretty damning for Mr. Blalock. I mean, you've sort of got the sequence of he's there, he's identified as running and shooting at the scene, and then you have the after the fact. And I understand that it could be construed another way, but saying, I knew that she was a rat, all those sorts of things, that's pretty bad evidence. And it's really sort of, for the jury, tough to hear those things. Why is it not possibly a reasonable strategy, something that a reasonable lawyer could do, to say, hey, watching this witness take the Fifth over and over again, when my strategy is create as much confusion and possible reasonable doubt, in other words, it might benefit my client. Why is that not a reason? Why could no reasonable lawyer have thought that?
For three reasons. First of all, this trial lawyer, who's a wonderful lawyer, and she's learning, she never tried a case like this at all. She tried.
But I'm not judging what she thought, right? It's an objective standard. It's not whether she had a good strategy. The question is whether any reasonable lawyer could have done what she did.
No reasonable lawyer would have done this. What happened was the prosecutor asked the following sets of questions that are germane. They're talking about February 23rd, 2019. Was Ms. Hartfield with Ms. Smith, the other person that we mentioned? Fifth Amendment. Was she in the area where the shooting occurred? Fifth Amendment. Was she with appellant that day? Fifth Amendment. Was she with the co-indictee that day? Fifth Amendment. Did she communicate with appellant on Instagram? Fifth Amendment. Did she arrange for the victims to get shot? Fifth Amendment. Did she enter the blue Charger, the car of the victim?
Why does that not
Fifth
just
Amendment.
let the jury infer that it's her fault and not appellant's fault, and this shift blame away from appellant to her?
That never happened. The only question she did answer,
No, but why wasn't the jury authorized to infer that?
because that would be unreasonable. She's
Well-
invoking the Fifth Amendment. Did I interrupt you?
No, thank you, but, I mean, it's, to say it's unreasonable, I mean, one juror might think that's unreasonable, one juror might think it's reasonable, we let jurors make those kinds of inferences.
Wasn't the argument articulated that she was covering for herself and others?
No. I mean, that really never came. That's what the prosecutor saying. The evidence, the argument was that there's not enough evidence to prove that appellant was there. That was her defense. And said, listen to these witnesses. The facts are not overwhelming, respectfully. Ms. Smith, who did identify appellant as a shooter, she gave total inconsistent statements. She was in the car, and she was impeached thoroughly. The Instagram messages are what I explained. They're not so overwhelming to me. I mean, when you cross-examine, which you couldn't on this because Ms. Hartfield wouldn't allow the cross-examination, that was not that bad of evidence. And nobody would agree that this is a good strategy. I don't believe no objective basis to believe that a reasonable lawyer would think, yes, let Ms. Smith handle the testimony and get confused. There's no confusion here. Ms. Smith did answer the questions on cross-examination by appellant's lawyer. Did she set up the victim? She said no. And did she direct appellant and co-indictee to do the shooting? She said no.
But you also said she's been impeached so many times, the jury would have been authorized to believe or disbelieve any of these answers, given how often she was impeached.
How was she impeached? She invoked the fifth.
You said she was impeached.
That's Ms. Smith.
Oh, I'm sorry.
I apologize. The Honorable Justice Bethel said potentially this is overwhelming evidence. There's an eyewitness. That eyewitness is I wouldn't want to call that eyewitness.
Isn't it possible that the counsel was trying to throw out red herrings to possibly have the jury think, well, we don't know what happened or who was responsible?
Counsel didn't even respectfully know that she could object to this procedure.
But that's
She not only didn't object, she helped craft the instruction.
That's the worst part.
And, but, and I'm going to let you respond to that. Back to the strategy and what a reasonable lawyer might do. Did I misunderstand that maybe Hartfield's counsel, the Blalock's counsel at trial, in closing, argued that this witness, Hartfield, was using the privilege to shield whomever she was protecting, and that she really set everything in motion and she was protecting the real killers whom she was trying to shield? I mean, was that the argument made by Blalock's lawyer at trial relative to her testimony?
That's a closing argument after the trial is broken, and this is how it comes out. There's no reason to put up Ms. Hartfield and allow her to invoke the Fifth Amendment. The lawyer didn't know about it. The problem we have here, really, that's bad. I think that's bad. But you want to talk about reasonableness and objectively under the Strickland standard. How about the jury instruction? At the very end, the jurors are now deliberating, and they ask, how can we use this Fifth Amendment invocation? And with the help, non-objection, and consent of appellant's lawyer, the court said, and there's more to it, this is a transcript of volume 11, 1465, line 8, through the next page, line 1. The trial court said that our Constitution guarantees that individuals cannot be compelled by the government to provide incriminating information about herself, the so-called right to remain silent. When an individual takes the Fifth, she invokes the right and refuses to answer questions or provide information that might incriminate her about this case or other. This is the part that I'm stressing. Now, this concept factors into your fact-finding and ultimate how this concept factors into your fact-finding and ultimate decision is for you to decide. And this court has explained over and over, we are going back decades, that when a witness invokes their Fifth Amendment, that cannot benefit or be to the detriment of any of the parties. That's why I have a problem with this, and that's why when it combined, you can't just look at it, to me, in isolation. That's why, without knowing the law, you could prevent the witness from testifying, and then couple that to tell the jurors, you can use this in your deliberations.
Well, that helps you on deficiency, but we still have the question of prejudice.
The prejudice, this court has seen more cases than I have ever seen. But I've tried a lot of cases. This is not an overwhelming evidence case, respectfully. I mean, you are the judge, you make better determinations, but to have an eyewitness that lies to the police immediately, that explains that she changes her story, even at trial she gets impeached with different versions of her story, she's in a car where people are now dead and she doesn't get charged. These are factors jurors take into consideration.
Mr. Steele, I think I understand your position on the strength of the overall evidence. Can you articulate the particular harm of this sort of colloquy and stating the fifth that you say sort of impacts the prejudice inquiry? Why was it so prejudicial, and why does that sort of tip the balance?
Because we know the jurors were interested in it. The jurors sent out a note during their deliberations
question.
asking how they can use it. They were given an erroneous instruction. And under our law, they should never have been allowed to use against appellant potentially the fact that were you with
And
appellant?
why was it likely that the way that this went down through the trial, that it would be used against the appellant rather than sort of in some other way?
It couldn't be any other way. The witness, Ms. Hartfield, said, I'm not involved in the shooting. I didn't direct the shooting. Were you with appellant? I'm not going to answer that question.
Well, while we still have a couple minutes left, could we pivot to another one of your enumerations? The second enumeration, the burden shifting and the comment on silence. I am troubled, particularly on the comment on silence aspect, but because it is brought through, and I intend to ask the state about that during their time, but because it's raised through the lens of ineffective assistance, again, that requires a showing of prejudice. What is the prejudice from the comments on silence, particularly when one of them, there was an objection made and the objection was sustained and the jury was told to disregard that one particular sentence?
Jury was told to disregard, I think it's 5 words of a sentence. They were not told to disregard that entire argument by the
Right.
prosecution. Telling a prosecutor, to me, as a reader, knowingly commenting on the accused right to remain silent is well beyond what we're doing here.
In terms of deficiency, I think that's a strong argument, and which is why I'm taking you straight to prejudice.
And to say to the jury, I want to know, I need to know, the quote is, if they were not committing the murder, where were they? And then if you read out the part that the trial court struck, if you disregard that, it reads like this. If they weren't committing the murders, where were they? They are both saying it wasn't. They weren't there. We didn't hear any evidence of it, obviously, but I would still like to hear that answer. And it's clear it's talking about where were they?
Well, the
And-
sentence before that, or the words before, we didn't hear any evidence of it, was preceded by, tell us where you were, implying that they had an obligation to not be silent, but rather defend where they were.
So I don't believe that the instruction was proper enough, go far enough, but your court always taught me that generally jurors who are sworn are bound to follow the court's instructions, and the court said, I'll sustain the objection, tell us where they were should be disregarded. So I read it out. That's why I did that.
Do you, counsel, do you think that Lampley, where we said, quote, you may not have every question answered because the only person that can answer all of your questions is the defendant sitting there at the table, was permissible? Do we need to overrule Lampley for you to win on this point, or can you distinguish that? I mean, is Lampley right, I guess is one question, but can you distinguish from that comment?
Well, respectfully, I don't think Lampley's great writing from the court, respectfully, I mean that respectfully. But I don't think you need to overrule it.
It does happen.
Not often, but I don't think that it needs to be overruled, because in context, the prosecutor here was clearly going at the fact that appellant did not testify. The appellant did not put in this evidence. There is no way around it. The lawyer, the prosecutor, was so prepared on his objection the first time by saying, no, Your Honor, it's not objectionable, because I prefaced it, I surrounded it with, there's no burden of proof on the prosecution.
But
under
Mr.
the-
Steele, there were objections here. So what is the ineffective assistance where you say, I mean, is there a piece of this that was not objected to that is the focus of this argument, or?
The only objection was burden shifting, and I thought this court taught that the objection should have been commenting on the silence. That's why I raised it. I don't believe that it is there's an objection, you just have to be honest with everybody.
And so the
There's an
ineffective
objection.
assistance claim is not the lack of an objection, but an objection with the wrong explanation for it?
Your court teaches that you have to make a specific, proper objection. I believe, if I'm wrong, then that's me on habeas, but I believe that the objection should have been the comments on the right to remain silent. So-
Counsel, let me ask, if the court excluded, tell us where you were, outside of that statement, how is it wrong for the prosecution to say there's no evidence?
Not what the prosecutor said. Prosecutor said, I would still like to hear that answer. It is still going to the fact that the appellant did not make that claim.
But is that directly enough to win your argument?
I hope so. I will find out.
Good answer.
Mr. Steele, that's a good way to conclude. Thank you for your argument.
Thank you so much.
Appreciate you being, thank you.
Let's hear the state's reply.
Bernie, good morning.
If it may please the court, my name is Alex Bernick, and I represent the state of Georgia on behalf of the Fulton County District Attorney's Office. I'm going to go ahead and jump in right into enumeration 1 here, as that's one we spent most time on.
So if, with your apologies, could we pick up where we left off there?
Of course.
And help me understand why this comment on silence, which is a different, you would agree that it's a different point than burden shifting.
Right.
Why that's not a problem to say, I would like to hear this answer? Why, you're going to tell me in a minute on prejudice that you had overwhelming evidence of guilt. Then why does a prosecutor need to stand up in front of a jury and play games with constitutional rights?
Well, I think this comes back to this court's, as I cited back in my brief to Ridley. Ridley states that where the defense...
Other than Lampley, none of the cases you cited apply to something like this. Ridley and Thompson, and I think it was Johnson or Jackson, they're all cases either about the defense's failure to offer other evidence. For example, defense lawyer says, all these other witnesses who didn't testify would have exonerated me. State stands up and says, you didn't even subpoena them. State offers lots of circumstantial evidence. Defense lawyer doesn't rebut the circumstantial evidence or explain it. Defense lawyer or prosecutor stands up and says, they didn't explain away that evidence. That's very different from the defendant didn't tell you what, something important. Evidence coming from the defendant as opposed to explained or argued by the defense lawyer is a very different thing when it comes to right to remain silent. And in our case law, the only case that I see that gets close to that is Lampley. And the statement there was really in context more of a throwaway than a principal point that was repeated through multiple sentences.
I'll disagree with you on that one. I think when you look at the closing argument in total, you'll see that this is a comment about defense attorney's inability to explain away or present evidence on their behalf. And as in Ridley...
In context, it's pretty clearly a comment on the defendant's failure to answer the question where he was.
Well, I think when we go back to the second closing, that's where we come back when the prosecutor begins the second closing. He explicitly references the attorney's argument there. He explicitly references, did you hear in the attorney's argument that there was any failure to explain? It wasn't about the choice to testify. It wasn't about whether the defendant testified here. It was clearly, throughout it, it was with expressed to the defense attorney's argument and failure to rebut the evidence, which is in Georgia law has been accepted that you can do. And
I know I sidetracked you on the enumeration too. If
Go
you
ahead.
want,
No,
you
go
want to do the
ahead.
Fifth Amendment thing, that's fine.
if you want, do you need me to address prejudice here?
We may come back to it. I mean, prejudice is going to be the same for all of the first three enumerations unless we get to cumulative. So if you want to talk about your evidence, you certainly can, but I think we're familiar with what the jury heard. Yeah.
I'll go back. I'll just go ahead and go to enumeration 1 then, with the text messages. Excuse me, text messages. Got the wrong one. Fifth Amendment. This is clearly trial strategy here. It's clear trial strategy. It's a coherent trial strategy. You see it in opening. The defense attorney asks why the two women were not at the table. and that the defendants were scapegoats. They were hiding something. Closing argument, the attorney comes back around and says, Mariah Smith and Hartfield are the ones who set this in motion. Why are they not here? And then we come back to the motion to trial where she testifies and she says, part of my strategy is to put the blame on them, ask why they were not there, and argue that the privilege was being used as a shield for him or Hartfield.
But how does that map on to the jury instruction? Because the jury instruction then seems to undermine that to some extent.
I don't think it does. I think the jury instruction complements trial strategy here. It allows them to build in this inference that, and while inferences are not allowed, it does allow her to build and argue that.
So it was good because it allowed something that's not allowed?
It can be.
Inferences of her guilt are allowed.
Inferences of her guilt are allowed,
Yeah.
right.
But can you explain how that addition to the jury instruction is supposed to be understood by the jury consistent with the Constitution?
On its face, it's more likely that it's not consistent with the Constitution, but we're here in an ineffective assistance realm, and so with trial
Are you
strategy,
conceding there was deficiency?
I'm not conceding, because
Okay.
I
I mean,
think,
because I think if you're, I get what your point is. It's not, the question is not simply, was this jury instruction right?
Right.
But at the end of the day, if what you're saying is, no, actually, that would be really hard for a jury to understand consistent with the Constitution,
Mm-hmm.
you know, then I think
but erroneous jury instructions are not necessarily per se deficient performance.
they're not necessarily, but it can make it, I mean, it really then points us to prejudice.
Right.
So what is your best formulation of that argument, that there is none?
There is none. I think we go back to Horn on this case, and Horn is very similar, and that was a direct review case. Horn asked whether there was any evidence of material facts that were added from the leading questions. It's very similar to a cumulative evidence in a prejudice in an ineffective assistance of counsel. And here I would say there was no material facts that were added, either as to appellant's guilt. If you were going to add there were any facts, any obvious inferences that were made, it was that she was a co-conspirator, and that's obvious from the evidence that was already introduced and independently introduced of this. Also, we do have strong evidence that was noted by the trial court who was in the best position to make that finding. They're the ones who saw the trial develop. They were the ones who also were able to just address credibility and weigh that evidence just as a juror would.
But counsel, how can you say that there was no inference that the appellant was guilty when she took the fifth on questions like, were you with him on that day? Do you know him? I mean, all those kinds of things where, I mean, wouldn't the inference, if the jury believes she was taking the fifth to hide something, she was hiding the fact that she knew him and that he was there at the scene on that day. So why would that not be an inference of guilt against Blalock?
Well, I think we come back also to her cross-examination testimony that she gave there. She denied setting them up. She denied directing Blalock or Ryan to shoot them. And so between the inference that could be created, as you suggested, and
Well, trial counsel argued she was protecting the real killers.
right,
Obviously, it wasn't Blalock, somebody else.
someone else. And honestly, she also took the fifth to saying that she had a gun that day, or she shot him. So you could also build that.
But is that a reasonable inference to draw? I mean, when the question is, were you with this defendant during the murder? And the answer is, I'm going to assert my Fifth Amendment right to avoid self-incrimination. No, I was not with him is not incriminating to her. The only answer that's possibly incriminating is yes, which then ties him. I mean, isn't that sort of by a wide margin the most reasonable inference to draw from that invocation?
I don't think so necessarily. I think it creates the gray area that she wanted to bring up. She wanted to hide the real killers. It's a gray area that she wanted to operate in, is to create this reasonable doubt, create that there's someone else out there that was in there. And I think she wanted to create that, and that ties into the trial strategy.
How does not answering the question of were you with this defendant during the murder doing that?
Well, I think the question was, were you with the defendant that day, not necessarily during the murder? And so that day is broader than the murder, than the time of the murder.
What else could be incriminating that happened that she wouldn't be able to answer about? Do you see, like, it seems like if she's invoking, then there's something she's worried about that's incriminating to her, which then leads to the inference that the presiding justice was suggesting.
Or could it be the inference of other prosecution activities that they had earlier in the day?
It could be a prosecution, other prosecution, the marijuana deal, the drug deal that she set up. Could be that.
Are those not part and parcel of what ultimately culminated in the murder?
They were, but not necessarily part of what was charged with the appellant here.
But I mean, if that's all they'd been involved with, and then there was a murder, you would have charged that as party to the crime, and we'd be here arguing about that. So, I mean, I don't see how that's really how that's potentially bringing in third parties through this inference. And the other problem is, if this was Jackson's sufficiency, we would say, well, it was a conceivable inference that could have been drawn, and we allowed juries to do that. But this isn't Jackson's sufficiency. This is Strickland prejudice, and we look to what inferences are reasonable and likely.
Well, Lawrence also says that it's obvious inferences there. And so I don't know if it's necessarily obvious that that Blalock was with her during the time of the shooting. It could be reasonable to infer, but not necessarily obvious.
Seems like it's a pretty reasonable, unreasonable stretch to draw that inference. I don't disagree with the question from the presiding justice. My question is, though, did counsel argue at closing the third-party inference that the jury was supposed to draw from the invocation?
No, she did not. And she just argued with respect to Hartfield was that, Mariah Smith and Hartfield clearly set this in motion. She focused more on Smith's testimony and the location of the bullets and ballistics.
Which makes the inference you rely on even more difficult.
More important.
I think
Oh my gosh.
It's not reasonable. If it's reasonable trial strategy, you would have presumed that the lawyer would have argued it in closing?
She would have, but she also, it ties into this argument here, this sentence here.
I mean, do we assess deficiency and prejudice in slices like that, or do we look at it in the context of the whole case? The question is not, could any reasonable lawyer have done this one discrete thing in the abstract? The question is, could any reasonable lawyer, and it is an objective standard, have done this thing in this particular context of the whole case, right?
Right.
Okay.
I think it's to the whole case, and we also see that this argument doesn't apply just to that they were lying, they were hiding. It doesn't apply just to Hartfield herself, it also applies to Mariah Smith. And so I think if you had it just applied to Hartfield herself, you'd have a bigger issue. But because it's Mariah Smith, you showed this trial strategy has been crafted to develop about the whole case itself.
So I apologize, excuse me if I missed this, but I'm not sure I've heard a prejudice argument from you that talks about, that assesses the strength of the evidence overall.
Okay.
Could you provide that argument?
Yes. Mariah Smith was eyewitness here. She identified appellant shooting and shooting into the vehicle. I think the most corroborating and circumstantial evidence is that we have those text messages that were sent, I guess Instagram messages were sent shortly after Mariah Smith and Hartfield had been picked up by law enforcement, interviewed by them.
Were those Instagram messages admitted? I thought there were some problems.
They were admitted. And actually, they were raised on motion for new trial, and they were not raised here in the Supreme Court. But they were admitted over objection. And those Instagram messages talk about why else would Blalock be interested in someone being picked up and snitching on him in a closely related time, and also knowing that she was a rat. So it's implied guilt there, implied.
I mean, so sort of by your own phrasing, you're admitting these are circumstantial pieces of evidence. Sometimes it's hard to get to overwhelming evidence by just circumstantial evidence. Is there anything else?
Well, you can. There's also the text messages that place Hartfield and Blalock and Ryan at the scene close in time. We know that both Mitchell and Hartfield were texting between the two. And Mitchell and Uten's story, even though they didn't identify Blalock, they largely corroborate her narrative of what occurred that night also.
And their description of the shooter is reasonably consistent with the physical appearance, although they couldn't identify anybody, right? So let me ask this. So basically, you've got evidence that the four were together, the two men and the two women. They split up, and the two women joined the three victims, for lack of, I mean, the three folks that were in the car when the shooting started. And then they moved to a new location. Women got out of the car in what appears to be a coordinated fashion, if we're taking the evidence in your way, and then shooting broke out. Right. And then after the shooting, there's this flurry of messages between the women and some of the victims and the women and the appellant, right?
Right.
And so when the appellant responds, I knew this person was a rat, is the only inference of that, I was guilty? Or could it be, I was double-crossed? There was somebody else and I've been set up.
Well, I think the inference is that he was guilty is because Hartfield sent that to both Blalock and Ryan. He didn't send it to anyone else. It was to them two specifically.
And did we ask afterwards, what did she say?
Yes, she did ask, what did she say? And so I think the obvious interest here is that we're still, and as I would put it, we're still in the concealment phase of the conspiracy here. And that she's asking about what happened. And this is closely short in time. There's no other evidence in the record of any other activities that could have incriminated him or them that happened after the shooting. And so the obvious inference here is that this related to Blalock's admission of guilt to his co-conspirator. If there's no other questions, I'll address the third enumeration.
Sure.
Of the text messages. Here we have the trial court found that there was deficient performance in failing to find the text messages. There are 2 text messages that were sent by Bernard Mitchell to a person with the Instagram handle PFK Don, and largely they both say we shot back. And while there was deficient performance in failing to find, the trial court found that there was no prejudice from them. There was no evidence that they would necessarily use them, and also importantly, that they were cumulative other evidence that had already been, in my words, debunked by Detective Hogan. Now I'll just go ahead and go to the cumulative here, is that Mariah Smith had already she told law enforcement during her interview, and that came out through Detective Hogan's testimony, that she had told them that Mitchell had shot back. And when that was presented, Detective Hogan said this did not make sense with the physical evidence at the scene. In order for it to shoot back, they were talking about the 9mm shell casings that were found at building, I believe, X, and the 2 that were found on top of the car. And when he testified, he said 9mm shoot, and when they eject, shell casings, they eject up and to the right. So for someone to shoot back at someone at that angle, the shell casings would have landed away from the vehicle. They would have not landed on top.
It is true that not all handguns eject. I mean, revolvers don't, right? I mean, so the fact that you didn't find casings from a third gun doesn't mean there wasn't a third gun, right?
Doesn't necessarily mean, and Mitchell and Uden both said they had guns, and Mitchell in particular said there was a 22. There's just no evidence of a 22 being fired there. And for the shell casings that were found, it was that Detective Hogan testified that a 22 does not shoot 9mm or 7.62 caliber bullets that were found at the scene.
Counsel, can you now address cumulative prejudice? Because, I mean, I've heard you talk about 3 enumerations, and it seems like there may be deficiency with all of that, and you've gone to prejudice. So you've got prejudice from taking the fifth, you've got prejudice from commenting on silence, you've got prejudice apparently from admitting these text messages. How is that not cumulative enough to warrant a new trial?
I don't think these are cumulative enough because I don't think they actually impact the evidence that was given that supported the defendant's guilt here. None of them take out...
That's a tough argument.
It is a tough argument, but I don't believe that they pull out any of the pieces that would support the defendant's guilt. It's not that you're removing, let's say, the Instagram messages that were circumstantial.
But all the evidence that you offered us to support the strength of the conviction was also circumstantial. So we're
Right.
pulling out, circumstantial building blocks in a circumstantial pyramid.
But they're not necessarily being pulled out here. As we've talked about, the text messages, they were largely debunked anyway. The jury had already heard it's cumulative. So you're not pointing out any evidence there. The failure to testify, there's no evidence that what he would have testified. There's nothing that's being debunked there.
But the prejudice is the fact that you alluded that he should have testified and he would have not been able to provide any evidence other than, he was at the scene of the crime. I mean, that's the prejudice there.
But there's enough.
Is it possible that that prejudice is also compounded in this context by the Fifth Amendment issue? Because the jury has heard instructions, not with respect to his not testifying, but about inferences they can draw about somebody who doesn't testify.
No, I don't think that's necessarily done. I think here is with the inferences that were made, they were with reasonable trial strategy, and that they supported the trial counsel's strategy here, that there was another person there. And so I don't think it benefits him at all, and I don't think it attacks that to any extent. If there are no further questions, I just ask you to confirm these convictions and sit down. Thank you.
Thank you, counsel. Thank you, counsel, for both sides for the fine argument. We'll try to have your decision as soon as possible. Thank you.
So I think they're going to move on to the next. Watch them clean out. Shout out to Brian Steele.
Madam
Steele
Clerk, will you
arguing
please
the
call
next thing?
case?
Yes,
Hold
Your
on.
Honor. Case
Why is he still here?
25A0023, Aaron Lewis versus the state. David Clark for appellant, Clifford Kurlander for appellant.
Okay, no, he's not. All right, so there we go. If you do want to continue watching this, here is the link to continue watching that live. Love watching stuff like that. As a quick roundup, you guys, let me know what you're thinking about that. I love watching appeal cases because it's so much more interesting to have a panel of justices. You can see different questions get asked. You can see a little bit of what they're trying to either challenge or solidify. And maybe we don't actually know if they're trying to challenge or solidify, but they're probing about some particular thing. And here, since this is Blalock v. State, we saw Steele present his arguments first. Then we get the response from the state. I know everyone's like, oof, the state, this prosecuting attorney from the Fulton County District Attorney's Office, his voice is getting quieter and quieter. In all seriousness, he had to deal with what seems like a mess of a trial prosecution. Unequivocally, the justices seem to agree whether there's prejudicial effect or not. Something that makes it a reversible error. It's harm, and it requires a reversal and a new trial. We have to wait and see if that's going to be the decision. But it seems to me that at least several justices think that the prosecution messed up at the trial level. And then this guy, who probably was not the prosecuting attorney during the trial, has to stand up there and make an argument why these convictions should stick. And he has to make that argument against Brian Steele. So I know we're like, oh, his voice is lowering. I mean, look at what he's got to step into. Look at what he's got to step into. Love watching this stuff. Now, a reminder here, we did look at the brief if you want to go into it in detail. The description of this video also has a folder with the briefs from Brian Steele, the response from Fulton County, and the response from the Attorney General of the state of Georgia. But really, we heard the enumerations of error. Those are the key points that Brian Steele was arguing were errors enough to warrant a new trial. It was prejudicial to the client, these different things. There were 3. And then he made a 4th argument that the combined impact of any or all 3 of these errors has a cumulative prejudicial effect. So even if you think maybe this was a little prejudicial but not enough, this maybe wasn't an issue at all, and this was a little prejudicial, maybe these 2 things combined, if you look at the prejudicial impact together, that cumulative effect, that's our 4th argument, are enough that this defendant, the outcome of this trial, we can't have confidence in it. We need a new trial. And the 3 separate arguments that Brian Steele argued were the trial counsel during this trial. We had Damone Blalock and we had co-defendant Rodalius Ryan. Right? So here we're focusing on trial counsel for Damone Blalock. Now, Brian Steele argued that this attorney at the trial counsel she didn't understand laws that were critical to defending her client, particularly in relation to a key witness, a witness called by the state, invoking her constitutional right to remain silent. Now, we heard a lot about that argument, and it seemed like the state wanted to focus on rebutting that because they weren't really sure how to rebut the other enumerations of error. But if you go through the trial transcript, maybe I can just show you. We looked at it at the beginning of the stream, guys. When we were reading that transcript, Miss Brazy, Tahira Hartsfield, who we did not see called to testify in the YSL trial. The state did not put her on the stand. They chose to call Mariah Smith, the other girl. And you guys saw what happened there. We also know the state planned to call Bernard Mitchell, that's BJ, and Rodney Uten. They're both in custody. We heard Leah Abbasi be shocked one day because, wait, I thought they were going to put those men on the stand, and suddenly they're not. And Abate ends up saying, that's not the case, ha ha ha, oops, yes it was. But Abate also said that they decided not to put them on the stand because in prepping with them, they both said that they weren't going to say anything on the stand. So the ops in this situation, 2 of the 3 men that were in the car, because Jamari Holmes is no longer alive, the other 2 men that were in the car, they're in custody currently. So the sheriff can get them rounded up to have them come testify. The state was going to call them until they said, all right, they're not going to say much of anything on the stand, so we're not going to call them. These are the witnesses that are making up the context for this Jamari Holmes murder case. So at the underlying trial here, for this murder trial, one of the star witnesses gets on the stand and over is repeatedly invoking her Fifth Amendment right, pleading the Fifth, to key questions. And occasionally when she does answer, the answers she gives are things that are self-serving, seem to get herself out of the mess. And let's not forget, Miss Brazy is also currently in custody for other charges, right? I believe like burglary of some kind, robbery of some kind, not exactly sure. She's in custody as well right now. So one of Steele's arguments was this trial counsel, you know, at the trial court, she was new, she was inexperienced. She has done a felony case before, but it had nothing to do with a murder. So this was her first time trying a murder case. And prepared for this trial counsel, including being aware of certain laws, certain case law regarding what happens when somebody takes a stand as a witness in a trial and repeatedly invokes their Fifth Amendment right. So that was Brian Steele's first argument of ineffective assistance of counsel. The second issue that he got into was, what was the second one? This, I think, was the pre-arrest silence was the second one. Yeah, to fully object. And we heard the justices go into this, right? And Brian Steele said, you taught me this, court. You guys taught me this. So, ineffective assistance of counsel by failing to fully object, in full, when the prosecutor intentionally commented on appellant's failure to explain where he was located at the time of the indicted crimes, hence appellant's convictions and sentence must be reversed. Now, we heard it specified that, well, yes, trial counsel did object to burden shifting. Later, we hear kind of an indicta commentary by one of the justices. I think it was the guy sitting over here. I think it was this guy. I could be wrong. He makes a comment like, well, if the state really thought they had such sufficient evidence that even these errors, there's still so much more evidence that this stuff, the prejudice of these errors wouldn't overcome the overwhelming evidence at the trial level. If that was the case, why did your prosecutors engage in burden shifting at all? So the Supreme Court justices here took an issue that Brian Steele wasn't even arguing, because trial counsel did object to burden shifting at the trial level while court was happening. But the justices still said, you know what, I'm going to take that detail and I'm going to ask the other side here, if you're really arguing that no harm, no foul because there's so much overwhelming evidence, why did your prosecutor need to shift the burden? That's not what they're supposed to do. But going back to Steele's argument about not fully objecting, what the objection should have been put on the record. When you make an objection, there might be more than one basis for an objection. And to put it on the record, you've got to state the objection. At least I know some courts don't do that, and I kind of hate that. But in Georgia, we see that, how many times in the YSL trial have you seen an attorney rattle off 1, 2, 3, 4 reasons for an objection when it's warranted, right? So at the trial court level, when the prosecution was commenting on pre-arrest silence, that's a separate constitutional issue that's at hand here. It's one thing for the prosecutor to shift the burden, but at the same time, they're also commenting in front of the jury on a defendant's decision to remain silent pre-arrest. You're not supposed to do that. And that's something we've seen be an issue with this prosecuting office in multiple cases. We've seen it be an issue in the YSL trial. They keep trying, the state kept trying to get in, especially Adrian Love, kept trying to get it in front of the jury somehow, some way, that, Jeffrey Williams didn't speak to police before he was arrested. He didn't want to go down to the police station and talk to the police himself, but he told Kenneth Copeland to do it. Adrian Love wanted the jury to make some type of inference about Jeffrey Williams' pre-arrest silence. You're not supposed to do it. Adrian Love also did this in, I think, a 2012 case. What the heck is his name? Kelvin Bradley? Kelvin Bailey or Kelvin Bradley is the man's name. Andrew Fleischman, attorney on X, you may have seen him comment on the YSL trial, was his appeal attorney. Ineffective assistance counsel argument, but also prosecution made big boo-boos. Adrian Love made big boo-boos at the trial court. One of the things, and the appeals court stated out that Adrian Love made this error, and it was harmful error. She commented factually incorrectly and legally improperly. She made a comment to the jury and brought it up in her closing statement that the defendant, he didn't want to speak to police and you should infer some takeaway of guilt on this defendant. Not only are you not supposed to do that, but it was factually incorrect because he did actually speak to police. So this is a problem within this prosecuting attorney's office. It's a second issue that Brian Steele is raising here, but the way he's raising the issue, it's not just that it happened and that the prosecutors did it. It's that the trial counsel did not raise the proper objection when it happened, right? So we're couching this issue under an ineffective assistance of counsel issue with an attorney that Brian Steele has established and made clear this was their first murder trial that they've ever tried, right? So you've got your second error here because she did not proffer the basis of the pre-arrest silence statements made by the prosecution, right? And then our third issue, which it seems to me like the state really did not want to address, the justices, the one justice, I think that same guy I circled, was like, hey, we left off talking about issue number 3, enumeration of error number 3. Can we start with that? And the DA was kind of like, okay. But that one was failing to realize that there was evidence that existed to disprove the state's theory of the case. So there was an issue there with trial counsel didn't go and look into a potential alibi and call the witness that could have given the alibi to the stand. So lots of issues there. And then the last thing, you guys have heard me talk about the jury charge, the instructions to the jury. I pulled it up on the screen for you guys to see. Let me find it again. Oh, I guess I can just pull it up here the way I did it. Now, the jury asked the question. They wrote a note and they said, look, Judge, what should we make of the witness invoking her Fifth Amendment right on the stand? Right? So that's a question that's coming directly from the jury, which means this is probably pretty impactful on how the jury ultimately makes their decision, whatever they reach as their decision after deliberations, if they're asking the question about it. So with the assistance of trial counsel, the trial court, the judge, announces the instruction that they're going to give. The counsel doesn't object. They're fine with it. And then the court delivers this. And this instruction is a mess. And we heard the justices hone in on this is, well, this instruction kind of instructs the jurors to make an inference that they're not supposed to make. So this instruction said, and you know what, I'll just read it here. We'll start with the actual question. How shall we interpret pleading the fifth? Let me make this bigger for you guys. Oh, and I always hate this view. So what page is this? 35? Let's make this bigger. And we'll get caught up with court. We'll skip the lunch break for the YSL trial, I promise you guys. But just trying to give you a little bit of background. And the justices have these briefs. They know this information. But we might not have this. If you're just tuning in for the oral arguments and haven't looked at this, you might be a little bit in the dark. But here's how the jury asked this question. Second question is, how shall we interpret pleading the fifth? The judge is speaking here. What I propose is to explain the fifth as follows, except I might be willing to say, if everybody is in agreement, let me start from the beginning again. The Fifth Agreement to the United States Constitution guarantees that an individual cannot be compelled by the government to provide incriminating information about themselves, the so-called right to remain silent. When an individual takes the fifth, she invokes that right and refuses to answer questions or provide information that might incriminate her about this case or any other. How this concept factors into your fact-finding and ultimate decision is for you to decide. You're permitting them to make inferences that they're not supposed to make. And the counsel, and this is why this is couched in an ineffective assistance of counsel with a cumulative argument. Prosecutor says, I think that works. Ryan's counsel says, I think that's great. And Blalock's counsel says, that's fine. So then they instruct the jury. They instruct the jury and they read it the same way. So there you go, you guys. We are going to be a little bit behind. I know. I know Latner's testifies, so we're going to get Latner's back on the stand. Thank you guys so much. I know I haven't been